Well, hello there and welcome everyone to this live stream. Welcome. I am Lior Samfiru, the employment lawyer. That's what they call me. And you've stumbled on my employment law session, my live employment law session, where I get to answer your questions about employment law, workplace rights, and anything under that heading. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us in Ontario, BC, and Alberta. And on this session, once a week, I log on here to take your questions, to inform you and educate you about your legal rights. So if you're having a workplace problem, man, are you in the right place? This is the time to get answers. This is the time to understand what to do. This is the time to understand if what your employer is doing is legal. If what your employer is doing is in accordance with the law, what to do, how to respond. Maybe you're being mistreated or bullied. Maybe your employer is trying to push you out. Maybe your job is changing, your compensation is changing, or maybe you lost your job. In all those situations, there are legal rights that you have. There are legal entitlements that you have, protections. Well, if you want to know what those are, what a great place to start right now. Just ask me the question. There's a box on your screen. You type in the question, you hit enter, and I'll see it, I'll read it, and of course, I'll answer it. Simple as that, can't be any simpler. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And the last few times I've been here, the last few times I've done this session, we had tons of calls. I want some more, or not calls, questions. And I'm looking for many more today. The opportunity to help you is really what I'm here to do every single week. Now, before we get started answering some questions, let me give you some other contact information. If you want to connect with me and my team off social media, off live stream, couldn't be easier to do that. All you do is you go to employmentlawyer.ca. See that address on the screen right there? Employmentlawyer.ca. When you go there, you can get the email addresses there. The phone number is there. The fax number, if that's your thing, that's there as well. You can fill in a form and we'll call you. It's as simple as that. And by the way, if you still have questions about employment law, employmentlawyer.ca, so many resources that we have there to learn, to educate, to understand your rights. And I'll give you some more information about that a bit later. But right now, I'm here live. Again, I'm Lior Samfiru, the employment lawyer. I'm going to start answering questions. But as you're listening to my answers, as you're learning about someone else's situation, ask me about your situation. I'm live. Take advantage. I'm not here every day. So if I'm here now, take advantage. Take me up on my challenge and ask me a question. All right, let's get going. Let's answer questions. Ask yours in the meantime. Don't wait. Okay, fantastic. First question on YouTube from Renee. Renee says, I've been working for a company for 10 years on an indefinite contract. The company then forced a 3-year fixed-term contract with no benefit for signing. It got extended for 2 years. Now they want to terminate me with no severance, total of 15 years. The job was a major function of the business operation. So the reality is, yeah, you are now a 15-year employee. It is very difficult, if not impossible, to eliminate that past service. The fact your employer just showed up one day and had you sign a new employment agreement, that in itself does not eliminate your past service, Renee. So you're now a 15-year employee, which means you're going to get severance as a 15-year employee. Depending on specifics of your job and your age, frankly, that could be anywhere from 16 to 20 months pay, even more than that. That's what's at stake. Now, your employer may say, oh, no, you signed the contract ended. Not so fast. You already had many years of service there. That service doesn't just get eliminated with a piece of paper. It doesn't work that way, especially when it was extended. So the message here for Renee and anyone, okay, your employer doesn't get to be creative to eliminate past service so that they don't have to pay you severance. But the better advice I'm going to give you is what I would have told Renee a couple of years ago. If your employer shows up to you and wants you to sign a new employment agreement, whatever the terms of that, don't do it until I see it. Okay, reach out, send it to me. Okay, let me tell you what it says, what it doesn't say, what it does, whether you should sign, whether you should not. Let's have that discussion. You don't want to just sign off on that employment agreement without going through that analysis. Okay, so Renee, now that you've been let go, you got to call me. All right, let's make sure I help you get what you're owed. To do that, very easy. Just go to employmentlawyer.ca. Again, it's on the screen, employmentlawyer.ca. Phone numbers there, email addresses there. Everything you need to reach out is right there. Thank you for that question. What a great question. If you've just joined us, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're on my live stream session where I get to answer questions to help you, inform you, and educate you on your employment law rights. If you're wondering about what to do, what to say, what your rights are, ask the question. I'm going to continue answering right now, so ask questions. Sandy H. has our next question. I'm based in Ontario, but my employer is in the US. I work as a call agent. They are saying that we are subject to the laws of their operations as their operations are from their state. Is that accurate? Absolutely not. Couldn't be more wrong. The laws that operate for you is the laws of Ontario. It's the laws of where you physically work. Doesn't matter if the company's out of Delaware. Those laws are completely and totally irrelevant to you. If you work in Ontario, regardless of where the company is, the laws of Ontario apply to you. And that's a fantastic thing, because guess what? In Ontario, we have far better employment laws that they have in the US. It's just the way that it is. That's how our laws are constructed. So you much rather be having the benefit of Ontario employment laws than the laws of whatever state in the United States. Not good. So what does that mean? That means many things. It means you get overtime based on Ontario laws, vacation pay based on Ontario laws, minimum wage based on Ontario laws. But it also, of course, means you get severance based on Ontario laws if you ever lose your job. So it wouldn't surprise me if they ever let you go, Sandy. They'll say, oh, no, you're pursuant to the laws of whatever state. We don't have to pay you anything, or we'll give you nothing. Well, no, you could be owed many months of severance, up to 2 years of pay. So now you know, Sandy, if you ever let go, call me. Any issues, again, call me. Very easy to connect, employmentlawyer.ca. Very important question. A lot of people ask me that when the company is based out of a different country. Doesn't matter. It's where you're located. That's the only thing that matters. All right. We're starting off strong today, guys, with some really good questions already. More questions have just come in, but please ask yours. Okay, don't be bashful. Don't wait till the end of the session where I'm saying my goodbyes and I'm not going to get to answer your question. Ask it right now. You got so much time. If you ask a question right now, I can guarantee you that I'll get to it and I'll give you the answer. So ask it right now. All right, let's continue. Next question comes to me from Facebook, and this is from Andrea. What kind of severance entitlements would I have after 13 years of employment? Great question. So, Andrea, the main factors that go into assessing how much severance you're owed are your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. Okay, it's as simple as that. Now, in your situation, I know one of those three factors. I know you've been there for 13 years. I don't know your age, right? And I don't know the type of job that you've had. But just based on those 13 years, it's probably not going to be less than 12 months pay. Okay, and it could be much more than that. It could be up to 20 months pay, frankly, based on your age and the type of job. So that's an assessment. But rather than just me guessing, because I don't know all the factors, let me tell Andrea and all of you how you can find out right now how much severance you're owed, how you can get an assessment right now in seconds, and by the way, of course, for free. To do that, we have a tool. It's called the Severance Calculator. To find that, you just go to pocketemploymentlawyer.ca. Kind of cute name, right? Pocketemploymentlawyer.ca. You see that address on the screen. When you're there, you click on the Severance Calculator, and you're there. Answer a few questions, and it's going to give you an assessment of how many weeks, months of severance you are owed. It could be 6 months. It could be 24 months. It could be something completely different. Use it. It's completely free. It's completely anonymous. Don't put in your name. It's not asking for your name or your company's name or your address, not even an email address. It's just there for you to get an assessment. And if you want, and only if you want, you can connect with me directly from that severance calculator so that I can actually help you get the severance that you're owed. So again, pocketemploymentlawyer.ca for Andrea, for anyone that has lost their job or are worried about losing their job, or maybe you're just curious about what you are owed. And by the way, spoiler alert, it's not a week per year of service. It's not 2 weeks per year of service. It's much, much more. Don't believe me? Check it out, pocketemploymentlawyer.ca. Thank you for that. Another great question. Fantastic. More questions are coming. Yay, I'm in a good mood. Fantastic. Let's continue answering questions. You please continue asking them. All right, let's see. Marina has our next question. Marina asks, if a company is liquidated, then as far as I understand, its employees are entitled to severance, but the company does not have the money to pay the severance. What happens then? So the reality is, you know the old saying, you can't get blood from a stone, right? So if there's actually no money and no one's done anything illegal to get rid of the money, then you're not going to get severance because there's nowhere for it to come. Usually that only happens in a bankruptcy situation. If the company is actually in bankruptcy proceedings, employees are not going to get severance. If there's any money, secured creditors are going to get that. But in the bankruptcy situations, employees are not going to get severance. There's just not going to be money left over. Now, the fact that a company is shut down does not mean it's bankrupt. The fact that a company is selling its asset does not mean it's bankrupt. It must use whatever money it has to pay severance. Okay, it's really just in a bankruptcy situation. So if the company is not bankrupt, but they're going through some process, contact us because time is not on your side. We may be able to do something now, but if we wait too long, there may not be any money. So connect with me and my team, Marina. Let's do that ASAP. To connect with us, very easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. And I just see here that Marina had a second question. May as well answer that. And that is, can an employer lower an hourly rate? So generally speaking, an employer cannot make significant changes to the terms of employment. So what I mean by that is they can make marginal, small changes. Generally speaking, if your employer reduces your pay by more than, say, 12% or so, that could be what we call a constructive dismissal. In other words, if they reduce your pay that way, you may have the right to consider that reduction as a termination of employment and force the company to pay you your full severance. Now, if they make a tiny change, 4%, it may not be that, so you may not be able to do much. But anytime it's more than, say, 12% or so, constructive dismissal. And one of the reasons you want to do that, you want to say constructive dismissal, is if you don't. If you just put your head down and accept the pay reduction, by doing that, you've given the company the right to do it again and again. So you don't want that to happen. So it's a question of how much they've reduced it. Marina, if you want to talk to me about constructive dismissal, if you want to understand if what they've done is illegal, very easy. Just connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Right on the screen, and phone numbers there, email addresses there. We make it very, very easy. Thank you for that question. By the way, if you've just joined me, welcome. I'm Lior Samfiru, the employment lawyer. You are on my live stream where you get to know about employment law. You get to hear me talk about employment law, answer questions, and answer your question. You can ask me whatever you want about employment law right now, what your rights, about what your employer is doing, about your entitlements, and I can answer and tell you what you need to know. Just like I'm about to do right now, I'm going to continue answering questions. Let's see. Lynn has our next question. Lynn says, I was just let go from my sales position. I had performed very well this year and was due a commission at the end of the year. I suspect they did this to avoid paying me. Am I still entitled to this? Absolutely, yes. If you've done what you needed to do to earn the commission, then you have to get the commission. So yes, you absolutely get the commission. The company doesn't get to pick a convenient termination date to avoid paying you money that they owe you. Not only that, if that's why they let you go, if we can show that they let you go to avoid or to try to avoid, that could be bad faith, which means they have to pay additional amounts. But before we even talk about commissions, Lynn, there's another issue here, and that is severance. Now, I don't know anything about your job, your company. I don't know anything of what severance they've offered you, but I can almost guarantee you that whatever they've offered you is less than what you're owed, probably a lot less. In over 90% of cases, whatever an employee is offered is a lot less than what they are owed. So, and that amount of severance that you're owed could be a lot more then the commission even. So yes, you're owed severance, you're owed commission. Now that you know this, Lynn, there's only one thing for you to do, and you got to do it. And that is to connect with me off air, okay? I want you to connect with me. The contact information is on the screen. It's employmentlawyer.ca. Got phone numbers there and email addresses there. It's there. Let's talk about the commission. Let's talk about severance. Let's talk even about other damages that may be owed to you. But I've said this before many times. A company cannot pick a convenient termination date for the sole purpose of trying to avoid money that it owes the employee. It doesn't work that way. The law's smarter than that. So, Lynn, please reach out. Again, employmentlawyer.ca. All right, fantastic questions, guys. So far, every question, amazing, love it. Thank you. Follow-up questions if you want them, or new questions, just ask them. There's no bad questions, right? There's only answers. There's only solutions. Again, I'm Lior Samfiru, the employment lawyer. This is my employment law live stream session where I get to answer your questions live, okay? I'm live, you're live, and ask the questions. Jen has a quick question here. Jen asks, do you have an office in Montreal? No, we do not. And we cannot represent employees in Quebec, okay? So if you work in Montreal, we cannot help you. If you live in Montreal, but you live in Ontario, then we can help you. We help employees all across Ontario, BC, and Alberta, but not in Quebec. For Quebec, you have to seek advice in that province. So thanks for that, Jen. All right. Questions. Love them. Fantastic. Let's continue answering. Anna has our next question. If you suspect staff are getting sick due to environmental toxins in the building you work in, because the building is over 50 years, suggestions on how to approach the manager and owner of this business. So you can approach them by expressing the concerns, and a good employer is going to want to do something, at least investigate this, because obviously the employer wants the employees to be healthy so they don't miss work, right? It's in the employer's interest for the employees to be at work every day, and they can't be at work every day if they keep getting sick. So you and the employer should be on the same page. So I would ask the employer, maybe the employer's already investigated this issue and they know that it's fine, or maybe they're aware of an issue and they're working on getting it better. So you can ask the question. But here's the thing. If you ask the question, you don't get a satisfactory answer, you actually have a right to refuse what you consider to be unsafe work. So if you think your work environment is unsafe, even if you're not sure, but in good faith you believe that it is, you have a right to refuse it. And what happens then is your employer cannot punish you, penalize you, cannot let you go, cannot do anything to you. They have to investigate. And if they investigate, you don't agree with the investigation, they have to call in an inspector from the Ministry of Labor who specializes in investigating, and that person will investigate and determine whether or not there's any issue in the air, any toxins, or any unsafe work conditions. So this right to refuse unsafe work is a very fundamental right that we have. You have a right to trigger that knowing that you cannot be punished. I would start by approaching your employer, ask the question, I have these concerns, I see people getting sick, can you investigate this? Have you investigated? What do you know about this? If you don't get a satisfactory answer and you legitimately are concerned for your health and safety, you can refuse unsafe work, all right? If you want to talk in the meantime, if you have any problems, if anything happens, or if you're not sure what to do, easy, just reach out to me, employmentlawyer.ca, again, employmentlawyer.ca, and we can have that private chat. All right, great question. I like talking about safety because it's such an important thing, right? I mean, really, it's the most important thing at all at work. We want to be safe so we can come back home to our families and not put ourselves in any risky situation. So thank you for that, Anna. Great question. All right. Again, if you joined us, I'm Lior Samfiru, the employment lawyer. You still have some time to ask your question. I'm going to continue answering questions right now because I want to make sure I get to all of them. But please, you got time, ask your question. Irregular Reg, love the name, has our next question. I've been working as a contract employee for the last 12 years at a local plant. They have said a number of contracts won't be renewed in 2025 due to work shortages. Are we not owed anything? Now, I'm assuming you're not part of a union, but absolutely, if you're not part of a union, of course, after 12 years, the law considers you to be a regular employee. You're not a contractor. Nonsense. You've been misclassified. You don't work for a company for 12 years, quote unquote, on contract or as a contractor. You're a regular employee. So if you lose your job, you can't stop that, but you're owed severance. Now, I don't know exactly the job that you're doing, and I don't know your age, but you could easily be looking at a year's pay or more than that. Okay, so now you know. This is actually a common situation when someone has been misclassified. Okay, you know that now. So once you know if you're losing your job, once you know when that happens, next step, call me. Okay, reach out to me right away. Employmentlawyer.ca is the way to do that, because the phone number is there, the email address is there, and I'll help you. Okay, and by the way, tell your colleagues, because your colleagues are in the same situation. Think about it. If it was that simple, no company would ever have to pay severance, right? We'll just call everyone contractor. Yeah, I know you've worked for me for 30 years, but I'm calling you a contractor, so I don't have to pay you severance. What a brilliant way to do that, right? Doesn't work that way, okay? Of course not. The law is a lot smarter than that. So you call me. Let's make sure you get what you're owed. Employmentlawyer.ca. Thank you for that question. Love that question. Very, very important one. All right. You still have some time. I'm going to continue answering the few more questions that came in, but I want a few more, okay? Don't stop. Let's make sure we get even more questions answered. The next question is on YouTube from Sarah. Are there any situations where an employer is allowed to refuse to pay overtime to staff? Well, there are some positions that are exempt from overtime. For example, managers. A manager is exempt from overtime. So an employer does not have to pay overtime to a manager. There's other positions. For example, certain professionals, accountants, doctors, lawyers, there's exemptions for them. And there's a few others, people in construction, etc. But if your position is not exempt from overtime, you have to get paid overtime if you worked the hours. Okay, the company doesn't get to avoid that. Now, some companies say, well, we didn't ask you to work overtime, so we're not going to pay you. No, you still have to pay. Okay, even if the company didn't ask you to work it, but you did because you had to, and the work was legitimate, the company has to pay you overtime. Now, depending on the province that you're in, there's different overtime thresholds. In Ontario, for example, the threshold is 44 hours a week. So anything over 44 hours is time and a half. So your company has to pay for that. So, but every province has its own threshold. But yes, you have to get paid for overtime that you work unless you're in a position that's exempt from overtime. Okay, so hopefully that makes sense, Sarah. Any follow-up questions, any problems? If they refuse to pay you, you know what to do. Reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic question, great question. Overtime, very important topic. All right, let's see if we can get some more questions in. You know what? If you ask a question, you'll still be able to get it answered under the wire. So you got time. Take the time. Write a question that you want answered. Send it to me. Again, I'm Lior Samfiru, the employment lawyer, and I'll answer it. All right, let's see. Crane for Ops has our next question. What's the difference between 1 week per year versus being owed more? Why is it that most companies say you're owed 1 week? Because they're wrong, or they're hoping you're not going to know any better. It's not a week per year. It doesn't exist. Now, your minimum entitlements may be a week per year, but who cares? Your full entitlements, we call those common law entitlements, are much more than that. And it could be as much as 24 months pay. And by the way, I'll give you one better. A short service employee, let's say someone that's only worked a couple of years, even a few months, that person that's worked for a few months is going to be owed a few months of severance. You're going to work for 6 months and easily be owed 4, 5, even 6 months of severance. So why does the company tell you otherwise? Either they don't know or they do know, but they hope you don't. They're hoping to get away with it. And here's the reality. If a company lets go 10 employees, let's say, and they offer all of them really bad severance, probably 7 of them or 8 of them are going to accept because they don't know any better. Okay, that's why I'm here, to make sure that people do know better. And I'm asking you to spread the word. Every single week, I'm contacted by people that accepted terrible offers, terrible severance offers, because they didn't know any better. They thought they had no choice. But by the time they realize they made a mistake, it's too late. I can't help them anymore because they signed. Never, ever, ever do that, okay? So Crane for Ops, hopefully that explains it. Any issues, any problems, let me know. Okay, thank you for that question. Let's see, question on YouTube. This one is from Fred. If you take on temporary work after being laid off, is the money you earned from the temporary job deducted from any severance settlement with your employer? Yes, it may be if it's similar position. I'll give you an example. Let's say you used to work full-time and then you're put on a temporary, or you've been laid off, let's say, but you take a job working at Home Depot on the weekend just to keep busy. Because that job is different, it's not going to be deducted. It's just something very different. If you find similar employment, it will be deducted. So the key is this. The key is to resolve the severance issue before you start a new job, okay? That's where you want to call us as soon as you're let go, so we can do what we do and get it resolved and get you paid before you find another job, all right? So hopefully that makes sense. Fred, any follow-up questions, just ask me. Happy to answer. Haney, sorry if I mispronounced, has our next question. Can I still get better severance if I already start to take EI? Absolutely, yes. You can, in fact, you can get severance. You can pursue severance up to 2 years after you were let go. The fact that you started receiving EI doesn't change the severance that you're owed. So if you lost your job, yes, you can get severance even if you've received EI, but you got to call us, okay? Let's make sure you get what you're owed. Let's make sure we do this right and we don't leave any money on the table that you're owed. So again, to connect with me, Hayne, Fred, any of you, very easy, employmentlawyer.ca. Again, employmentlawyer.ca. All right, I'm going to take one more question for today's session. Love that. Lots of questions today. It's fantastic. This one is from Mr. Arts. I requested a leave to take care of my wife after she had a stroke. My employer said it is too much of a burden and they need to lay me off. I don't know what I should do. Well, what you should do is very simple. You call us, okay? Let us tell your employer that it's not legal, that they have to accommodate you, okay? They can't decide now that you can't be off work because under human rights laws, they have an obligation to accommodate you. We call this accommodation based on family status. Okay, if your wife is sick and you have to provide care, they have to accommodate you. In addition to that, there's other leaves that you can get because it's a serious medical condition. So there's several leaves that your employer would have to give you, and they can't decide to lay you off because of that. So it's illegal. So what would happen here is once they hear from me, they'll say, okay, yes, of course, sorry, of course we'll accommodate you, of course we'll give you a leave. We misunderstood, but they got to hear from me. So now that you know, I want you to connect with me, all right? Connect with me through employmentlawyer.ca. I am very sorry to hear about your wife. I hope that she gets better and you can take care of her. Let me deal with your employer so that you don't at least have the stress of losing your job, all right? So connect with me through employmentlawyer.ca. All right, guys, this is the time that we have for today. Lots and lots of questions came in today. Fantastic opportunity to help you. Great questions. I know that the questions are not ending just because this session is ending. So you can continue talking to me. You continue asking questions, continue getting help. And you do that very simply by reaching me and my team off live stream through employmentlawyer.ca. Again, employmentlawyer.ca. Not going anywhere. Our team is ready. We're helping people every single day. So make that call, send the email, go to the website, again, employmentlawyer.ca. Thank you for joining me. I'll be back soon, but in the meantime, you know what to do, how to reach me. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Thank you so much for joining me. I'll talk to you all again very soon. Bye-bye.